for remote hearings. Only speak when invited to by the chair. If you wish to speak, please raise your hand and direct all communication via the chair. Please ensure that your mics are muted when you are not speaking. When speaking, please be succinct and do not exceed the allocated time frames. If referring to any written submissions, please refer to the specific page number in the agenda pack. Any new evidence can only be submitted at the discretion of the chair and the agreement of all parties. If you are having technical difficulties, please use the chat function to alert the meeting or dial in using the details in the invitation. Please do not use the chat function for putting formal questions to the subcommittee, I beg your pardon. Any persistent disruptive behaviour will result in removal from the meeting. Once the review has been considered, any parties remaining will be asked to log out of the hearing. Please do so promptly so that councillors have the opportunity to deliberate and make a decision. Parties will be notified of the decisions within 5 working days. However, you may contact the licensing service tomorrow for a skeleton decision. Thank you. Members, if I may invite you to appoint a chair.
I'd like to nominate Councillor Garbett.
Seconded.
Thanks, everyone. I think it's over to me now, isn't it? Yeah, great. Welcome, everybody. Thank you for bearing with us as we got going. I'm just going to take us through the agenda and the bits and pieces we need to do, and then we'll get into the meeting. I've been looking at who's here, so I think we have got everyone here that we were expecting. Just the other persons, as in residents and people making representations, I know it's a bit strange that you've been assigned a kind of letter and number, but obviously your name does appear on the screen. If you do want to remain anonymous, let me know, but otherwise it's a bit strange to not use your name if I can see it, but I just like to say that at the beginning. But yeah, let's move through the agenda. So Amanda.
Yes, Chair. Chair, if you'd like to confirm that Councillor Maxwell is just observing.
Oh yes, sorry. Yeah, so Councillor Maxwell is here observing, and Councillor Root and Councillor Lufkin and I are the panel. So have we got any apologies for absence? None received, I don't think. No.
None received.
And then agenda item number 3 is declarations of interest. So do any members in the committee have declarations to declare? Councillor Lufkin.
I was Mr. Rahili, who's one of the who appears as one of the witnesses, is an ex-colleague of mine on Hackney Council. I don't think it affects my ability to make a decision on this case.
Thank you. And Councillor Root?
Same. As above.
Thank you. Thank you both for declaring that. Minutes of the previous meeting. There are no minutes for consideration. And agenda number 5 is the licensing subcommittee general information and hearing. So I think Amanda was going to help me outline. Oh, Leo, I can see your hand up.
Yes, Chair. I'll do that now. Sorry.
Great.
Did you say someone else had their hand up?
Yeah, Leo's got a hand up.
Okay. I've also just found the hand up function on Google Meet. Sorry, I don't use Google Meets that often. Councillor, through you, I'm just trying to understand what it means that it was an ex-colleague. I think that's sort of quite important, particularly because, well, I don't know. I have a suspicion, so perhaps we could just know whether it's an officer of the council, a councillor, contractor, from councillors Lufkin and councillors Roth.
Yeah, I'm going to take advice from him. I can see Tom's got his hand up, but just if officers want to come in, or should I go to Tom?
Chair, if I can just help to assist before Mr.
Rahili
makes his comment, is that this was in the course of council business. They were operating as councillors. The members here attending this meeting today have only had known him through the council as a council member, but they've not had any direct dealings with him. They've had no dealings with this premises or his ward council business, etc. They are not part of the same wards they're separate. You know, there's no involvement there, but they're just declaring it as a point because of the fact that he was a member of the council previously.
Are they from the same political party?
I'll let members confirm.
Yes, we are all from the same political party, but as Amanda says, none of us were representing the same ward.
Members, I think if you can confirm that you've had no communications, or when you last had any communication with him, if you did have any, just for clarification, that there's not been any.
No, as far as I'm aware, I think Mr. Really stepped down from the council in at the last election, or perhaps even before. I can't remember.
Just confirm roughly the date so that there's clarity.
And, yeah, I haven't
Let's
seen
Mr. Rahili, can I let Mr. Rahili come in and just clarify some of those points? Hopefully that will bring some
So,
clarity.
for confirmation, I stepped down prior to the last election. I stepped down I can't remember the exact date, but I took up a job that required me to be politically restricted in March 2020. So I certainly wasn't a councillor in March 2020. I've had no communication and in any form with either Councillor Lufkin, Councillor Rout, or Councillor Garbett from that date onwards, or other than in general council business. I think with Councillors Lufkin and Rout in any form, largely prior to that, we've certainly had absolutely no communication in relation to the case at hand today. And as others on the call have said, we were not ward councillors, and we've never, even as in my time as a councillor, discussed the goings on at the Adam and Eve pub.
Thank you, Mr. Rahili. That's very clear. Leo, you waved. Did you want to come
Well,
back in?
Ma'am, yes, I'm afraid it is clear, and I should explain. I'm on a WhatsApp group with my clients. So if I look at my phone, I'm not being rude or checking Instagram. So what I'm hearing is that two councillors have declared a potential interest. They've then called on this person to effectively answer for them. They are from a common political party. They are Labour Party members. They are Labour councillors in Hackney Council. And while I accept that they say that they've not discussed the case or had cause to discuss the case, as your legal advisor will know, one of the things that I'm just being asked to really just think about is the issue of not just bias, actual bias, but perceived bias, because perception is of vital importance. So here we have a Hackney councillor and two other councillors from the same political party. I'm just going to ask my clients to just take a moment and let me know if they're concerned about this. And perhaps, Ma'am, if you could just continue with the if this is okay, just the sort of admin notes, and then I can just come back on whether we're concerned about this opinion. It's okay. Thank you. I should say,
there's a question in the chat, Leo. Sorry, could you just introduce yourself?
I'm the barrister representing Adam and Eve. Sorry about that. Thank you.
And just to confirm that I've never met Mr. Rahili. Just that's why I didn't declare an interest, and I'm in a different political party. So just before we conflate things, but yeah. Okay, Amanda, I think we've agreed that we're going to go, unless you have anything to add on conflicts, why that was.
I think Mr. Rahili will just want to say one last thing before I read out the hearing procedure.
Chair, it's not to say anything now because it might not be necessary, but subject to whatever Leo comes back with, it would just be helpful to, if I have the opportunity to kind of understand the position from the legal advice from Hackney Council. Like I'm a Hackney resident. I have a right to participate in the democratic structures of the council. As you say, Councillor Garbett, we have never met. I have had literally no contact with Councillors Lufkin or Rout, social, professional or otherwise, since I stepped down from the council. We have never discussed any matters relating to the Adam and Eve pub. As I think my fellow residents just put in the pub, this isn't about political representation. This is about my right as a resident of Hackney. And so I would, subject to what Leo comes back with, I'd appreciate a view from the Hackney legal team as to how I'm able to exercise that right. Should there be any objection to that?
Okay,
Mr.
thank you. Can I just
Davenport,
can I
if I can
just
just ask-
reiterate? Hang on a minute, Amanda. Can I just reiterate to not use the chat for anything but technical questions? If you do have a question, do put your hand up and I'll come to you. I appreciate this is a slightly frustrating start, but if you just put your hand up, we'll make sure that people's questions get answered.
Yeah, sorry, that was
Amanda.
what I was going to say. Thank you, Chair. That's correct.
Okay, if I think we've agreed to, if you read out the hearing procedure and then
procedure,
we'll come back to the issue.
Okay, so
you.
hearing procedure type C is what is applicable to this meeting today. Step 1, the subcommittee will appoint a chair and introductions. That's been done already. Step 2, the licensing officer will outline the report, and that will take 5 minutes. Step 3, the applicant's case. The applicant will present their case, that's the licensing authority in this instance, as they've made the application. They'll read out their case in support of the application for a review, and that will take about 5 minutes. Step 4, responsible authorities in the case. There aren't any here, so we won't be referring to them. There is environmental protection, apologies. Environmental protection may be making representation. So if they make a representation at step 4, that will take 5 minutes, where they will highlight their reasons for making the representations in support of the review that's been called. Step 5, other persons in the case. The chair will invite other persons in attendance to present their case and highlight their reasons for making it a representation in relation to the review called, and that will take 5 minutes. Step 6, the premises license holder will be able to respond to any issues, and that will take 5 minutes. Step 7, discussions. The chair will lead a discussion on the information presented and give subcommittee members an opportunity to seek clarification on any point raised and ask questions if necessary, and that will take about 15 minutes. And step 8 are the closing remarks. The chair will ask all parties if they have any final comments to make. These comments can only be in relation to issues raised during the discussions, and these should be brief, and that will take 10 minutes. Everyone will then be asked to leave the meeting while members make their decision, which will be confirmed tomorrow. Thank you.
Thanks, Amanda. That's really helpful. And just for this part of the meeting, just before we conclude the next bit, I'm just going to ask people to say which part that they think they're speaking to, and then everyone will know who's in the room. So if I just say the part of the agenda, and then can someone just say if that's the bit that they're going to speak to? So I've got the principal licensing officer.
Before we start, can we go back to Mr. Sharalambidi's?
I'm just going to do this bit so everyone knows who's in the room, and then we can conclude that, if that's all right. I don't think this will take very long. I just want to make sure that everyone else knows who everyone else is. I think that's just to be clear. And then the applicant, I think that's David.
Yes, that's correct, Chair. I'm the applicant.
Yeah. Okay. And then next we've got the responsible authority.
Environmental protection, that's Gertch Patty.
Great, thank you. And then we've got the other person, so I'm going to let you identify yourselves, and then I'm going to follow with how you identify yourselves. So I've got D1, if you know who you are. Great. And how would you like to be referred to? Are you happy to be referred to as D1, or are you happy to be for me to use E?
I'm really sorry, I can't see those letters numbers. So
okay.
But I can say that I'm in step 5.
Yeah.
I'm in step 5.
Okay. I'm going to refer to you as D1.
On the papers,
and then,
on the agenda, it sets out D1 to D4. So that's where you'll be referred to as the relevant person.
Yeah, I'm sorry, I couldn't see that on the printout that I received. Oh, I see, it's from the representations at the back on the appendices. Okay. The thing is, they're blanked out as to who submitted them.
I know.
We know.
I know. It's a very strange thing that it's this kind of strange anonymous thing, but then it's actually not anonymous because you're here. So it's, I'm trying to be sensitive, but it's
I can say that I'm a resident. I'm
okay.
A resident, yeah.
Okay. Great. And then D2.
Happy to. I think I'm D2. I'm pretty sure I'm D2.
Yeah.
And I'm happy to be referred to. Well, we've already referred to me by name. I'm happy to be Mr. Haley or D2, whichever you prefer, Chair.
Great. Thank you. And then D3. you know who you are. You're here to speak.
Hi, it's me.
Oh,
It's
okay.
Miss Harvey. I'm trying to currently still log on, but I've got you on the phone.
Great. Okay. Got you as a telephone number. Great.
Yeah.
Okay. And I don't know if have we got D4?
No, Chair, we don't have D4.
No. And then who's speaking on behalf of the premises license in that section?
Mr. Sharal-Ambidis.
Yes,
Okay.
that will be me, Mom, and I do have the premises license holder, a consultant, and the acoustic expert available if they're needed to answer any questions.
Great. The holder, the acoustic expert, and who was the other one? Sorry, because
The premises license holder
okay.
and the consultant. Yeah.
Great. All very helpful. Great. And then we'll have the discussion. Great. Hopefully, is there anyone else that I haven't mentioned? Mario's here to kind of help with technical stuff and recordings. Anyone else?
Chair, does Mario need to assist the local resident who's on the phone?
Oh, yes.
Maybe.
Yeah, that would be helpful. Yeah, Mario, if you're able to help Miss Harvey get into the meeting, that would be great. Thank you. Great. Okay. So I think we're going back to Leo just to confirm whether
But my interjection wasn't about whether or not Mr. Rahilly can participate, but it's actually whether and how it looks where the council have fielded 2 Labour councillors, where there is a recent ex-Labour councillor making representations, how that looks to my client, how that looks to the public, and you know, the way in
just
which.
to say, unfortunately, because of the political makeup of the party, you've actually got the most diverse panel that you can get, because it's me and all Labour councillors. So I think we've struggled to get.
I do
struggled to get
appreciate that.
panel.
But it's just worth highlighting. We don't want to we don't want to hinder or delay
Yes.
the hearing, but it is something that and we don't. Well, we just want it minuted that there is this concern. But I hear what the councillors have said, and that they've not discussed it, and that's really helpful. So that's what we need to say. Thank you.
Okay, Amanda, I'll come to you, and then Councillor Rapp.
Yes, I was only going to clarify, Chair, that there aren't any other members that would have been able to sit from the other parties. So we are actually limited in who we would have had available. Otherwise, we wouldn't be able to hear the application at all. Thank you.
Yeah, and Councillor Rapp.
I just wanted to, I'm not quite sure what we're noting here. I mean, it seems to me that either Mr. Sharal-Ambidis is objecting or he's not objecting. And, you know, I mean, I suppose what I'm looking for is some reassurance that he's not going to try and appeal on these grounds, because I think that would be rather unfair, actually.
Was that a question to me?
Yeah, I think that was a question to you.
Yes, well, I'm just raising it as a concern. I'm really looking forward to a discussion and an appropriate remedy as set out in our evidence. I'm not even thinking about an appeal at all. But I think it would be remiss of me not to have raised this on behalf of my client. But I think we can all sort of move forward aware that there is this concern, and we'll certainly, for my part, just you know, observe where we're going. You know, my interest is to promote the licensing objectives, and to do so in the context of this discussion. I've heard what everyone has said. To hear where everyone's at with this.
Yeah, I'm gonna. Yeah, and just to add, I think everyone's been really clear that, you know, Mr. Raheny has a right as a resident to be participating in this, and that's exactly how, you know, we have a professional kind of standard that we're expected to meet as councillors in terms of conflict of interest. So I think that's absolutely how we'll be operating. I'll just let Councillor Lufkin come in, and then we'll hopefully try and move on.
Yeah, I've got to say, I'm with Councillor Root. I'm a little bit concerned now. You know, if we spend hours deliberating and then, you know, the decision doesn't go the way of Mr. Sharal-Ambidis' client, is he going to use that in evidence against us? I mean, or when in the appeal? in which case, what are we doing here? You know, do we need to get some other councillors who've never served with Mr. Rahilly? Because you know, I don't fancy sitting on a committee that you know, if it makes a decision that goes against Mr. Charalambous' client, that we then have that the whole thing is then appealed on the basis that I'm a councillor and that I'm a councillor at the same time as Mr. Rahilly. I think we need, you know, I'm minded to say that we shouldn't continue on that basis, because I don't think I can participate fully.
I think this has been a really useful discussion. We've bottomed out the relationship between councillors. You've all said you've not spoken with each other, and we've highlighted that there are concerns that there might be you know, a perception of bias that will only be confirmed you know, in terms of our conduct. The fact that we're also cautious about our conduct fills me with encouragement. I'm really not interested in thinking about technical appeals. As I say, we've prepared an expert report directly dealing with the primary concerns, and what we should be focusing on is whether or not there is a nuisance here. What is of concern is that we're all thinking about what might happen on an appeal. That's not the approach that any of us are thinking about. I'm not thinking about an appeal at this stage. I wouldn't even know what my appeal would be because there isn't a decision. So I'm personally very happy to continue with the 3 councillors that we've got.
Okay, thank you. Councillor Rout, I think you were first.
Yeah, I just really want to point out that I'm not even sure that we needed to declare this conflict of interest. I think we were doing it in the interest of transparency rather than legal requirement to do so. And as such, it does distress me that if we were to go forward, if there were to be an appeal, that these grounds might be brought for that appeal. I feel that we are abiding absolutely by the Code of Conduct. We've stated exactly what little contact we've had, and even little contact whilst we were councillors. And I just feel that I don't want to end up wasting council money for an appeal on this kind of basis. That's my concern, and I would like something a little more forthright from Mr. Charalambous before we spend a lot of time this evening and then potentially go to appeal. I mean, it is only a very, you know, it's only a potential, but you know, there are public funds involved in this, and I don't want to see that happening on the basis of this argument, which I consider to be somewhat spurious, actually.
Well, as I said, I'm really content. I really welcome the openness of this discussion. We've had it. I think it's been really useful to have, and I'm content to proceed with the committee as presented, and I'm really looking forward to having the discussion on the substantive points.
Great. Okay. Mr. Ridley.
Thank you, Chair. Just for completeness, and I did say this in my submission to the panel, but on the subject of kind of conflict of interest, and hopefully this is reassuring to Mr. Charalambous and his clients, the Adam, this is an issue that I've lived through as a councillor, as a resident of the ward, but never raised during my time as a councillor because I didn't want to perceive the abuse of power, as it were, that might curate. So I lived through all this. It is not an issue I dealt with as a councillor. I didn't raise it as council business. I didn't try and kind of progress it in the way that I know residents did at the time because of the issue of the perception. I don't think there is a conflict of interest in that case. I have a right as a resident, but because of the perception of conflict of interest during that time. So for completeness, Chair, I just wanted to raise that too. So hopefully that gives further reassurance to Mr. Charalambous and others.
Great, thank you. And Councillor Lufkin?
Yeah, I'd just like reassurance from our legal officer that she thinks that it's okay that we go ahead and it's not a grounds for appeal. Yeah, if that's forthcoming, then I'm happy to go ahead with this. But if I mean, if it was raised by Mr. Charalambous, so we didn't raise it. He said, I'm concerned about it. I want to know that before we go ahead with this whole thing, that we that she doesn't think that that's grounds that could be used as grounds
Yeah.
for an appeal?
Thank you, members. I think that both Councillor Root and Councillor Lufkin have been very clear and transparent about their position, and I do feel that you can proceed. I don't feel that this will be a ground for appeal, but obviously, should it arise, I feel that we have enough here to state clearly, according to the minutes of the meeting, that it was clearly discussed and everyone was open and honest about what was needed, and therefore I don't think that a court will find against members that they have acted in breach of their code of conduct or that they've done anything incorrectly. As Councillor Root said, both members made their declaration, just in the interest of transparency and to ensure that they were operating properly as council officers. And so I think as Mr. Sharolambides is happy for us to proceed, I'm confident as well that we can proceed. I'm sorry, obviously, that this discussion has taken the length of time it has, but please be reassured, I think that we can proceed and hopefully come to a decision at the end of this meeting. Thank you.
Thank you. That was very clear. Okay, let's get going then. And I will go to Suba as the licensing officer to present the report. You have up to 5 minutes.
Thank you, Chair. So the item we are going to consider is for an application received by the licensing service from the licensing authority for the review of the premises license under Section 51 of the Licensing Act 2003 for Adam and Eve, 155 Homerton I Street, on the grounds of the prevention of public nuisance due to the noise complaints received from the usage of the area of the external part of the premises located at the rear. After the consultation period, we have received representation in support of the review from the environmental protections and 3 other persons and 1 from other person against the review. We have received also additional information from the representative of the premises license holder, D1 and D3. All these documents have been circulated and I have nothing else to add. Thank you, Chair.
Thank you. That was incredibly succinct. Thank you very much. I'm going to move on to the applicant presentation.
Thank you very much, Chair. So this application, as you've heard, is an application to review the premises licence under Section 51 of the Licensing Act 2003. The review application is sought on the grounds of the prevention of public nuisance. Complaints have been received and continue to be received from nearby residents living near to the premises, to Adam and Eve, and these are as a result of the use of the external, or some parts of the external part of the premises at the rear. I will stress at this stage that for me, there's no concerns about any other part of the premises. So internal parts of the premises, smokers that have been moved to the Homerton High Street facade, there's no concerns on my part about that activity. But just review and the concerns that we have relate purely to the use of the garden. So in the application, I set out some of the background and that the complaints that we received date back to before the lockdowns that were as part of the coronavirus pandemic measures. Obviously, with the pub not in operation, those complaints ceased. Then the pub reopened and the complaints resurfaced, especially once normal operations were allowed to continue or resume. So in my application, you'll see I make reference to a closure notice, which was served relating to this matter, but it was not pursued to seek a closure order as liaison took place with the licensee before the new license application was sought. You'll see reference in the application to that new license application that was made by the licensee last year. You will note that this application was refused and the reasons that were given by the subcommittee that considered it. I therefore applied to make this review application to seek to remove the specified areas of the plan because of those complaints that we continue to receive and the suggestion that the use of those areas, bottle store, covered yard, by customers was undermining the promotion of the licensing objective, in particular the prevention of public nuisance. I also sought to attach 5 new measures as licence conditions. So that would be a modification of the licence to attach those licence conditions. But what I didn't reference to in my application was that the licensee had previously volunteered these measures, and there's no suggestion that we have that the licensee isn't continuing to carry on with these measures. I note the additional submissions which have been circulated, as you've heard, and I welcome those, including the very, very detailed acoustic report. And no doubt that we will get to this in the discussion. So I'll conclude my opening submission there, but just to reiterate that this application is on the basis of nuisance, which appears to be as a result of the use of the bottled store, the area on the plan referred to as bottled store, covered yard, which are no longer used in that way, but are instead being used by customers. And it's this use which appears to us to be what's leading to the prevention of public nuisance objective being undermined. So I'll leave it there for now, Chair, and expect us to go into further detail in the discussion phase.
Thank you. That was really helpful. I'm just going to go to the subcommittee to see if they have any points of clarity on those 2 reports. I say no from Councillor Lufkin. Anything from Councillor Rupp? No. Okay. Wonderful. Thank you. That was really clearly set out, as well as noting those additional reports we've had and welcoming those. That's really grateful for that clarification. So I'm now going to go to responsible authorities who've only got environmental protection. If you'd like to do your presentation, Gaz, and you've got 5 minutes as well.
Thank you, Chair. I promise I won't take 5 minutes. From an environmental protection perspective, there's not a lot more that I could possibly add than David's already stated. Environmental protection's representation was merely to highlight the type of complaints received, but environmental protection hasn't actually witnessed a statutory noise nuisance. Environmental protection does feel that the proposed conditions could help prevent the disturbances to nearby residents if they are officially added to the premises licence. But other than that, I think David's clearly highlighted the concerns. No need to repeat those. I think we can move forward.
Thank you. And I'm going to ask if there's any points of clarity for that report. Is there anything additional anyone wants to ask at this point? Councillor Rao.
I'm just wanting to check. I think that Mr. Patty's had 1 additional complaint this year since the ones that were listed in the pack, but no others. Is that correct?
That's correct. So the last one that I received was on the 13th of May.
Thank you.
Great. Thank you. And Councillor Lufkin.
Mr. Patty, thanks for that. Is it your, I don't know if this is for the discussion phase really, but I'm just going to ask it now. Is it your view that the covered areas should be not used?
I honestly, I couldn't say that, because if we had witnessed a nuisance, we could possibly say, look, this is one of the causes for concern. But at this stage, I could not.
Fine, we'll come to that in the discussion. Thanks.
Yeah. So, Mr. Patty, just to confirm, when you said you're happy for the conditions to be added, you were referring to the written conditions that Mr. Tuitt listed,
Yes.
specifically those, rather than the plan. And so you haven't made you are not making an explicit decision on that bit, but you've agreed written condition.
Yeah, those other conditions would be helpful. Yeah.
And just to confirm that when you said you haven't witnessed it, what can you just describe a bit about what you've done when you received, just for clarity, when you received the complaints? Can you just explain a bit about what you did when you've received the complaints?
So generally speaking, when we will receive a complaint during out of hours. Let's say, for example, this is on a Friday or a Saturday night. It doesn't have to be necessarily night. It could be at 7:55 p.m. for example. The noise report would come through to us. The officer will try and contact the complainant to say, is the noise, for example, still ongoing? Can we come and make a visit? But unfortunately, on each of these occasions, that report has come through to the council of a noise complaint. We haven't actually managed to witnessed that disturbance, and on most of the occasions we've had to leave a voicemail on the complainant's phone to say, look, please call us back if it is still ongoing. But usually, I think, especially quite recently, the garden area closes by 10 p.m. and even when we have called prior to 10 p.m, we still haven't been, unfortunately, been able to get hold of the complainant. So again, no actual nuisance has been witnessed.
Okay, that's helpful for clarity. Mr. Rahimi, this isn't the discussion. You just before you make your point, I'll bring you in, but I'm just about to bring in the other persons to make your representations, and then we go into a discussion phase. This bit is just for councillors to ask kind of additional questions. So unless you've got just a point of clarity, it's not to kind of cross-examine people at this point. So
Sorry, it was. Chair, tell me if it's appropriate to make it later, but it was try to be a point of clarity on this point about not witnessing. When I have made complaints, I've often received the call, and I completely understand the constraints on the noise team. I've often received the call back from the noise team after 10 o'clock at night, by which time the garden is closed. I've often received that call after I have gone to bed. So just to make sure that the committee understands there's a distinction between not witnessing because it's not happened and not witnessing because it's not been possible, because by the time the noise complaint team have come back, it's been after 10 o'clock after the garden is closed. And I think that's an important distinction just to clarify at this point.
thank you. And Councillor Lufkin. Sorry, Councillor Lufkin, are you coming in?
Councillor Lufkin, can you hear us? I wonder if
Oh.
he's frozen. He may have
Oh, he's
frozen. He
left.
may have to
Yeah, we'll just wait for him to come back in. Are you back, Councillor Lufkin? Great. You want to come in and ask a question and make your comment?
I'm sorry, I don't know, this might have been addressed in the bit that I was away for. But are you saying that you haven't witnessed the? Yeah, I think Mr. Rahili was kind of raising this as a point when my internet connection dropped. Are you saying, Mr. Patti, that you haven't witnessed the complaint because you haven't been there, or are you saying you haven't witnessed the complaint, you've been there and it wasn't a nuisance?
We haven't been inside the resident's home. We have, as Mr. Rahili just said, there's been occasions, I'm guessing historically, where our officers perhaps called after 10 o'clock, but we have attempted to make proactive visits where we would arrange earlier in the evening, but for whatever reason, we haven't been able to actually be inside the resident's home to make an assessment for the statutory noise nuisance.
Okay, thanks very much.
Thank you. That's really helpful. And Mr. Sharlami, just to be clear that, yeah, just same as I said to Mr. Hilly, obviously we'll get to your part in a minute, but just if we had a point of clarity or a comment.
Just about your procedure, ma'am, either you're going to allow comments or you're not. And so, you know, if Mr. Rahili and others are going to be allowed to interject, then I would like that same courtesy too. So either we follow the agenda or not. That's all. Thank you.
Okay. Do you have a comment?
No, just that we follow the procedure.
Thank you. Right, let's move on to other persons. So we've got resident E Devonport as the first representation. So we're going to give you up to 5 minutes each, but if I just be clear that if people can make new points if you come after the first person, just so we don't have kind of a repeat of the same comments. So you get 5 minutes, but I will interject if you're making kind of a point that we've already heard. And we have read and obviously seen all the kind of documents that have been sent, just so everyone knows that we've received those. So E Devonport, if you want to start with your 5 minutes.
Okay, I don't think I'm going to take 5 minutes, hopefully. So I'm here to support this application from the council in terms of designating what is on the original plan, the covered yard and bottle store, as no customer access areas because the license doesn't cover those areas. And that has been at the crux of the ongoing issues with this pub since 2021, when we realized that they were using outside areas illegally for commercial use that were beyond the remit of their license. And that can be seen in the various plans throughout the various complaints, and also the review of their application last year, which was rejected because of the fact that it was made on grounds that they already had a license that covered the covered yard and the bottled store as areas for customer use. That's actually erroneous. They only have the beer garden, which is the triangle part. And the point of this review is to basically ensure that they are sticking to their license and therefore reducing the amount of public nuisance that has been created over the last 3 years to amongst the residents at the back, but also securing the future for residents in terms of knowing that this pub will be basically operating within the remit of its license. I think in terms of, reporting noise, that's obviously been less since the rejection of the license in the autumn. And that's because also I think the pub has had to kind of think about the fact that there is still an issue around the covered yard and the bottled store, and that we hoped that that was going to be resolved through the review in July last year, but that wasn't the case. But prior to that, there were 17 reports made over 15 months in terms of the nuisances that this pub was causing with loud noise, with serving customers right up against the walls of the gardens of where we live. I don't think that the Adam and Eve have been generous or supportive or community focused in terms of how they have worked for the residents. I think the acoustic report should be inadmissible because I don't believe an acoustic expert can comment on public nuisance or comment on how many residents are allowed to or can comment on the noise that is made. But the acoustic report was made completely on its own by the pub without any consultation with residents, despite us saying that we would be interested in doing this, but with someone that we all had a say in choosing. And the acoustic arrangement that has been put in place, which looks like a kind of weird wooden fence, is clearly not having any impact, but that's because of the fact that they are still using parts of that internal area.
30 seconds, just to let you know.
That's it.
I didn't mean to cut you off. I was just
That's
letting you
okay.
know if you had any final points to make.
No,
Councillor Rao, do you want to come in?
Thank you. The point of clarification, really, I mean, this clearly there were a lot of problems with noise earlier on, but as I understand it, there haven't been any reports of excessive noise from the 15th of July 2022 until the 13th of May 23. That's the best part of a year, isn't it? Are you saying
That's
that?
right. I think it might. Is this not a discussion?
No, it's a point of clarification, really.
Okay.
Have you been making complaints during that time or not?
Yes, I have. I have been making them. We haven't made them as frequently as prior to July, and that's also because they've changed how they've used the outdoor space. So basically, it's now a seated area in the covered yard and the bottle store, whereas prior to that, they were basically using it for events. So they were having things like dog shows, and so it was more like a space where lots of people could congregate, standing up, kind of having an event. As a result, I think, of the license being rejected, they've moved into putting seats into those areas and having people sat down.
Sorry, we've strayed a bit from the original question.
Yeah, the question.
The
Yes,
question was, have you been
Oh,
making complaints in the
yes,
last
no,
kind of
yes,
year?
and I put that in my I put that in my email that I had continued to make complaints. I just want to add
to the
Sorry, I'm gonna have to move to the next the next witness
Sorry, Councillor
statement.
Garbutt, can we just check that we're talking about complaints to the pub or complaints to the noise team at the council? That's just what I'd like for clarification.
I've been reporting noise complaints to the council.
I think we need to we can pick that up in the discussion around that point back with the other responsible authorities. Amanda, did you want to come in?
Yes, Chair, I didn't know if it was helpful at this point to ask what was the date of the last complaint?
I think it's the one I made in May.
That 13th of May one that I think was mentioned earlier.
Yeah.
Yeah. Okay, we can pick that up in the discussion. Okay, Mr. Hilly, I'm coming to you now for 5 minutes.
Thanks, Chair. I'm also here to speak in favour of the council's application. I just want to say from the off that this review is taking place because of the Adam and Eve's seeming unwillingness to deal with the issue or comply with their licence, and really urge the committee as a minimum to agree with the officer's recommendations. To some extent, to speak to Councillor Rout's point, this is an issue that is about the warmer summer months where noise from the pub is absolutely unbearable and it genuinely becomes a public nuisance. So we haven't seen a great deal of complaints over the winter because it's not an issue in the winter. It's an issue in June, July, and August, and into the autumn. And then it doesn't surprise me that there were fewer complaints over the winter. But during those warmer months, it is genuinely a public nuisance, which is obviously the material kind of consideration of this committee that impacts on residents' well-being and quite frankly, on mental health. You know, that's noise of shouting, of loud jeering, of chanting, of a garden that backs directly, of a pub garden that backs directly onto residential space. It's noise that, despite what the acoustic report says, is audible in the front room of my house, the furthest part away from the pub, when all the doors and windows are closed. It makes my garden space completely unusable. It's like sitting in a very, very loud pub garden. It interrupts my kids' bedtimes. I've had my children say to me on numerous occasions, "What's that noise? It's keeping us awake." And it's persistent and it happens all the time. I dare say also, Councillor Wright, actually, and I know this speaking to residents, complaints have dropped off because no one has seen any change. And so people have been worn down and have stopped putting them in, or they put them in by different routes. They put them in by emailing them to the licensing team rather than using the app, because people don't know how to make those complaints. So I really would urge some caution in terms of handling, because it is an issue that persists. The pub, as Ms Davenport said, produced a noise report. They said that they were going to do that independently, but it's been a report that is not independent. It's commissioned by the pub for the pub. And despite its claim to be independent, when I read it, it had huge amounts of subjectivity or judgment within it. It's a report that was done between April and May. So it's not carried out when this is a problem. It's not a report that's measuring the level of noise when there is a problem during those warmer kind of summer months, despite what the report says. We don't see an issue in winter. We don't see an issue in spring. It is terrible in summer. And just as an example, you know, that report says, oh, well, it's not, you know, despite what I say, it's not an issue that affects my children's bedtime because nighttime starts at 11 o'clock. And tell you what, a 4-year-old and a 2-year-old's bedroom does not start at 11 o'clock. So it seems a slightly ridiculous position to try and set that out. This isn't an issue because, you know, it's all happening before 11 o'clock. Yeah, I just really, if I've understood the pub submission, to get round this, they seem to be saying, well, this is off-license sales and we'll continue to use the space. The council has always been really clear that the bottle stores, the covered yards should not be used under their current license. That's why they bought the previous licensing, so the pub could try and legitimise the use of this space. It was roundly rejected by the committee last June, and nothing material has changed since that position. So I don't really see how we can come to a different position today. Actually, I'm really concerned about the way in which the pub said, oh, we're going to use this as off-license space. We don't actually need to even bother with the concerns that are being raised by the council. And so actually on that basis, I really urge the committee to consider further conditions. I'd like the committee to place a strict limit on the numbers that can actually be in the outdoor space at any one time. If you look at the area that's covered by the council's proposals and the table space that's there, I think it's reasonable. That's about 10 people. And so I'd like the committee to limit the numbers in the outdoor space, whether that's on sales or off sales, to 10 people. I'd like there to be no vertical drinking, so everyone has to be seated as a result, again, as a measure to kind of try and constrain numbers. And whilst it might be a small thing, I'd really like a condition that the pub has to keep the doors between the main pub and the garden closed. At the moment, they routinely prop them up if it's admissible, or I can show a photo evidence to prove that. It sounds like a small point, but it's demonstrative of the behaviour of the pub, and it means that noise from the main pub also transfers into the garden space and also transfers into residential areas. It is complete. This has to be a partnership between the pub and the community. The pub has not demonstrated that willingness to work. They've demonstrated trying to work around whatever was, the judgment of the committee last June, saying we're not granting that license, you shouldn't be using this space, and then they've continued to use it. So I really urge the committee to accept the conditions in the report, plus those additional conditions of a limit of 10 people in the garden, no vertical drinking, and that the pub must keep the door between the pub and the garden space closed at all time. It is a matter of public nuisance, and that's the material consideration of the committee. Thank you. Sorry, Chair.
Thank you, Mr. Hilly. No, that was I know you got through a lot of information there, and thank you for raising some of those concerns, and lots of stuff for us to get to in the discussion, but also I'm sure that the applicant is listening to all the things you're raising to respond in their section. I'm going to come to Miss Harvey now for your 5 minutes. If you are happy to. Oh, sorry, you're on mute. Oh, sorry, you're on mute.
Yeah. Hello. Yeah. I haven't got much to add to what Emma and Thomas said. The only thing that I will add is that I was born in this house at number 3 Glen Road, so I've seen the changes for the last 60 years. Yeah. I submitted a plan, the original plan of the Adam and Eve pub. Yeah. It's a plan that shows in March 1936, that is when Adam and Eve first got the extension, the back half of the pub, the lounge, and that's what put the property butted up against neighbours. The bottle stores, as a child, you'd be able to go down that alleyway. It was an open area, and bottle stores wrapped around. As I said, I've sent in the documents to show that pub, the last time it got planning permission was in 1936. As I said, I've been here from 1960, and there's never ever been any further planning that the locals, me, has been aware of. I've watched them from 2015 start to cover up these areas. Yeah. What I'm saying is, it's devastating for me. I'm in pension age now. Yeah. And to be subjected to this when I know I've lived there for years and never had that problem. So that's all I've got to say.
Thank you. That's really helpful. We did see the documents that you shared, so that's really helpful to see, and thank you for that contribution. Yeah. I'm now going to move into the premises license holder section. So I don't know who's kicking off from your end.
Well, I am.
Great. So you've got 5 minutes for your contribution.
Mom, thank you very much. You can see from the application and the submissions made from your officers that there are really few complaints about this premises. In fact, there are none. There are no direct complaints made by the licensing authority or indeed the environmental health authority in this regard. You'll see the only controversial matter that Mr. Chivett is asking for is how we deal with what has been described as those two cupboard areas, and you'll see that from the plan on page 25, where you'll see on the plan no customer access, and that's the bottle store and the stored area. But more significantly, Mr. Chewett makes a very significant request at page 17 of his application. He says, there's been no independent or external assessment of the effectiveness of these works. So what Mr. Chewett is doing is he's saying, I'm not an environmental health expert, I'm not a noise expert, I need someone who is to make this assessment. So we turn to environmental protection. They clearly are experts, but they've chosen not to exercise their expertise. What they do is they leave a message on the answer phone of those who've complained. They've not been into the residents' homes. They've not examined the two areas that are in discussion, and they've not made any visits, either before, since, or during this application process. So they are not experts. And in fact, as you can see, they confirm to you, we adopt what David says. So in effect, we've got no complaints. There's no statutory nuisance. We've not visited. And when asked directly about the plan point, ma'am, they can't answer you because it's a very technical issue. If you look again at page 25, you'll see that those two areas, those cupboard areas that are described as cupboards by Mr. Lufkin, are potentially echo areas. And what we've done is we have appointed that independent expert that Mr. Chewett has asked us to do at great expense, no council expense. He has signed a declaration of independence, and he has said that the measures that have been requested have all been complied with. Mr. Chewett confirms that, and he says what Mr. Chewett is asking for will make things worse. They will make things worse because by having people in that central garden and no people in those cupboards, you're effectively echoing noise. What the expert confirms is that if you put people in there, they will soak up noise. He confirms that as a result of observations, both the soundscape of the surrounding area, the character of the area, the fact that the premises has been there for, well, over 100 years, if not longer. There is no public nuisance. You have an expert telling you there is no public nuisance, and he tells you, as Mr. Chewett requests, put in some absorption material in those areas, which we are willing to do, improve the high-level screening, which we are willing to do, further adopt the measures we are already undertaking. You'll note that Miss Davenport says she's making less complaints, things have improved, and they can be relied on. Effectively, ma'am, this application is ill-founded. The measures are working, they continue to work, they can work, and if you give Mr. Chewett what he's asking for, it will make things worse, not better. And that's because the expert that Mr. Chewett has asked for has confirmed that his request will make things worse and not better. So by way of conclusion, we are offering up further acoustic measures as set out at paragraph 7.01 of the report. We are offering up our noise management plan as a refreshment of matters, and those 5 things that Mr. Chewett asks for are already done, and we are happy to add those to our premises license. Ma'am, thank you very much.
Thank you. That was incredibly succinct and covered a number of points, and I'm really positive to hear about the acoustic report recommendations being taken up, and obviously we all agree on the conditions, which is really positive, that were being put forward by Mr. Chewett, which is helpful. I am going to move us into discussion phase, but I'm just going to there's a number of points that I've got that I want to get into, but I am going to let my councillor colleagues come in first. Yeah, I'll let Councillor Lufkin and Councillor Rauch come in first, and then I'll come in with some questions. We've now got 15 minutes, so just after 1:15, for a discussion phase, which is where we will ask each person who's made. Oh, were there any points of clarity? Sorry, both just of Councillor Sherrill. Oh, Councillor Lufkin. Oh no, change your mind.
Yeah, Don't worry, it's more of a discussion phase question, actually.
Okay, so I'm gonna, so, sorry, Emma, was that an additional, you just, because now I was just asking for points of clarity from the councillors. They're the people that do the points of clarity at this point. Great, you will have another opportunity because I'm sure people will have further questions of the statements that you've made as witnesses. Great, let's move into the discussion then. Didn't notice my fellow councillors wanted to kick us off, but I could go first. Councillor Lufkin.
Yeah, I'm got some questions about this acoustic report. Did the person go into? I mean, there seems to be a direct contradiction here. You know, Mr. Rahilly and Ms. Davenport, or at least Mr. Rahilly, talked about being able to hear the noise in his sitting room, and I think all the residents think that it's very noisy. Did the acoustician go in or visit the residents, and did they try and contact them?
So it's, if you look at page 26 of the supplemental bundle, you'll see some photographs there. So the residents weren't contacted because previously they did not wish to cooperate. So we asked for an independent expert, and in order to achieve the assessment of what is audible at the boundary, you'll see there the location of the microphones. The acoustic report also raises issues about the soundscape, so the impact of the traffic and so on, which is actually noisier than the outside use. And so, as you're aware, you need to be very careful when hearing submissions from laypersons, which are passionate, subjective, and indeed very personal. And I think this is why Mr. Chewett asks for an independent assessment, which is what we've done. The independent assessor is able to take into account the soundscape, the use, the location, use proper recording equipment, and bring his expertise to bear, which is why he is able to conclude quite appropriately that there is no nuisance, and indeed your own environmental health officer has said there is no statutory nuisance. So when Mr. Rahilly says our well-being and our health are being undermined, if that were the case, they would pick up the phone, they would have people visiting round, and your officers will be able to use their own equipment and their own ears under the Environmental Protection Act, because they are under a legal duty to attend and investigate. None of that has happened, which is why you're also able to adopt the conclusion of the independent expert that there is no public nuisance at this venue that is actionable.
Okay, so in answer to Councillor Lufkin's question, no, it wasn't done in the homes, it was only done in the gardens. I'm going to let Mr. Rahilly come back on the point around
But
the
Mum,
inclusion.
can I just ask you about your discussion? As far as I'm aware, your discussion is for you to ask people questions. I don't get, unless I'm wrong, and perhaps
But I have just asked
if you
Mr. Rahilly a question. Yeah.
So there was a
Right.
question. There was a question about the report and our involvement.
I was just gonna ask Mr. Rahilly to come back directly on the point about the residents being included, because I know that was a part of your representation that you just made, which was that you wanted to be included but weren't. I was just trying to get to the point of, yeah, not being included in the acoustic report.
And I completely appreciate it's Mr. Charalambidis's job, but he does seem to be somewhat trying to lead people into views about what does or doesn't impact on us as residents. So we were never, sorry, in discussions, the pub said, and this is actually historically, like a year or so ago, they said they would commission this report independently with us. We were never involved in the commissioning of the report. It was a report commissioned by the pub for the pub. In this report that's in front of the committee now, at no point did anyone make any attempt to contact me, and I can see Marcia nodding, and I can see Emma. So I know they can speak for themselves. At no point did anyone make any contact with me to attempt to measure noise levels at any point in my house. So, you know, and I think that sort of demonstrates the attitude and the approach of the pub in all of this. The previous report, actually, there was one attempt made to come and measure not by any pre-appointment. So this is not the report in front of you now, but the report that was in front of the committee last June, but just to demonstrate the approach that the pub has taken to these quote unquote independent reports. The contact that was attempted to be made was someone knocking at my door at, I think, 7:45 while I was putting my children to bed on a rainy Wednesday night in, I think, April from memory, when there was no noise problem, and that was their attempt to measure. So final point on the report, because Mr. Charalambidis has made repeated assertions about its independence and its its objectivity. My reading of the report, and obviously councillors will make their own judgment, is it is littered with subjective statements that are not about the noise, but are about the assumptions that you should draw from that. And I really urge you to discount it on that basis.
Okay, thank you for those points. I know that you made those earlier. Councillor Lufkin, did you want to come in quickly? And then I'll go to Emma.
Yeah, I've got another question, really. I don't know.
Oh, hang on. Okay, I'll just go to Ms. Davenport then. Yeah.
Thank you. It was just to basically speak to the point being made that there haven't been any complaints about noise since.
I'm gonna come to that in a minute, because that's a kind of separate point. I want to ask the environmental protection about that in a minute. That's the point that I want to move on to next after Councillor Lufkin's point, if that's okay. I have noted that there's this conflict between how complaints have been made, who they've been made to, what complaints have made, and noting the representation that was made around people, this conflict between if things have improved or if people have just stopped reporting. I have noticed that we need to kind of bottom that out a bit. Councillor Lufkin.
Thanks, Chair. Yeah, I'm just slightly concerned that the pub seems to be using the premises, using all aspects of the area, even though they've been asked not to. And I'd just like to get some view on that from the licensing authority. Is it the view of the licensing authority that they shouldn't now be using the two areas, the two covered areas, and are they using it? And do you have anything to say about that?
Max, that's a very helpful question. Yeah, Mr. Stewart.
So the pub what the pub is saying, the additional submission is that the off-sales that's permitted by the license. So the license authorises the sale of supply of alcohol for consumption both on and off the premises. So what the licensee has responded to say is that the off-sales would allow them to use those areas, the bottle store and a covered area. So the purpose of this application is to restrict those areas completely from customer use, to remove any ambiguity about whether it's an on-sale, whether it's a sale, etc. That's what this application is seeking.
Is that helpful, Councillor Lufkin? Have you got any?
Yeah, that is. So they're using it anyway. They think they've got the right to, but and we're now clarifying that. Okay, fine, thanks.
Councillor Rao.
Yeah, I don't quite understand why people are being allowed to drink in these areas, which are clearly part of the premises. If they've got off-sales rights, then the off-sales is for consumption off the premises. These may what we're talking about is people consuming alcohol on the premises and in an area which is not licensed. It's not part of the licensed area of the premises. The off-sales isn't about consuming alcohol off. It's about off the licensed premises, if you see what I mean. So what I'm trying to say is that when they're consuming alcohol in that area, they are not off the premises, and therefore it's not off license. Surely, I don't understand what the confusion is there.
Mr. Charalambidis, did you want to come back on that point from the applicant's perspective?
Firstly, there's a premises as defined under the Licensing Act 2003, and where licensable activities can take place. Typically, it's shown as a red line. In this case, the pub has been around for so long, indeed, as Ms. Harvey has said, and they've been using the outside area on her evidence since at least 1936, if not 1960, that they're entitled to do so. So the premises, firstly, to use the area that is licensed. Hackney doesn't have a plan for that. We have said that the premises license always included those outside areas, irrespective of where we are. Even if that's not correct, many times a premises, which will include the car park and a beer garden and outside areas, are not part of the red line premises license, but are part of the premises in terms of the way it operates. And so the fact that the transaction occurs inside the premises and then people take them out of the licensed premises into an open area means that they're fully entitled to do so. So whether it is part of the premises license or not, they are acting entirely lawfully, appropriately, and in common with everyone else. And you'll see that in the section 182 guidance under the description of what is a beer garden and an outside area, and also in terms of where do sales happen. So there is nothing unlawful, nothing inappropriate about the operation of the Adam and Eve in respect of all their outside areas in their entirety. What we are looking at now is a very narrow technical question of whether or not using the two, I'm going to use Councillor Lofkin's description of the two cupboard areas, but the two cupboard outside areas, whether that leads to public nuisance or not. You have a clear experts report that says no, and in fact you have a clear experts report that says using those adjacent areas will reduce public nuisance. And it's
I'm just going to keep us on this point. Thank you, Mr. Sharon. That was really helpful clarity from the applicant perspective and from the position of the premises use.
Well, it's a legal perspective. It's not a personal perspective. It's what the law says. And I'm sure both David Tuitt and Amanda Nouth can confirm that.
Yeah, I was just going to go back to Mr. Tuitt. I can see there's lots of hands up and we've only got a few minutes left for this section and I really want to go to the environmental protection to ask some questions. So I'm just going to go back to Mr. Tuitt and then I might move us on to that point. Mr. Tuitt, do you want to come back on any of that?
Well, it's the reason this is a review application to just establish which areas shouldn't be used by customers because of the complaints that we receive.
Yes.
Hence why we've applied to review the license and restrict customer use for those areas. Sorry, oh gosh.
No, I've got you still.
Am I back? Yep.
Yep.
Okay. Hence why, as I say, it's a review application and not, we didn't seek to prosecute or anything like that.
Yes. Okay.
So I didn't want to get too wrapped up in the detail about on and off cells, etc. Just make an application.
Yeah, we're more agreeing around appropriate use of the area within its context and how the nuisance that it causes.
That's right.
I can see all three of you have got your hand up, but I'm really aware that we're meant to be concluding this section in a couple of minutes. I really want to get into the comments bit, the complaints bit. So I might not take anyone's comments at this point, just because I feel like we've clarified that point around use, and I want to keep us focused on the use rather than get into that. I hope that's acceptable to everybody. And that might be
Chair, or if it's acceptable, would I could try. I could try and do something on behalf of all quickly or not. Okay, it's up to you, Chair.
Yeah, and if I was going to take anyone, it was going to be Miss Harvey because the other two have spoken more. So if Miss Harvey wanted to make one quick comment, I'll take that.
Right. Well, as far as I'm concerned, for the 60 years that I've been here, from my memory from 10, that area has never ever been used like that. In fact, it was all enclosed. They were outside spaces, and also on the deeds to this property, and for the deeds that run along the back, it's all of it's covered with restricted covenants. So I'm very sure that if it's checked on land registry, you'll find that the bottle stores, all those areas around will be covered with restrictive covenant, which says there should be no sales of beer or alcohol.
And I think that's the technicality that we're getting into, that it's not used as an area of sales, it's used in an area of consumption within the rights of the premises to use its land. So I think this is where I think Mr. Tuitt was saying that let's not get too technical, but I appreciate I appreciate there is that difference in the history and the change that has happened over the years in terms of the usage. Okay, I'm going to take chair's rights and just ask Mr. Patty a couple of questions. I quickly wanted to get a response just on the your perspective on the acoustic report that's been provided and what the authority perspective is on that, and a response on what you've heard around the complaints that have or have not been received over the last year. I know we've had the reports of the official ones but you know, as we can hear from some of the witnesses, there are other complaints have been made, and it's just I'd like a bit of clarity on that. I think those were my two key questions. Also, just a note from Environmental Protection about kind of pre-pandemic complaints, because I know that was a point in one of the written submissions, like has this been something that happened before or evolving? So Mr. Patty, is it all right to answer those questions? So one is the view on the acoustic report, complaints that have been received that we've heard that have been made but not maybe reported in your report, and then a difference between pre-pandemic and now from your perspective.
Yeah, okay. So technically, the report, there's not a lot that I could pick apart, shall we say, in a negative sense. But I do take on board, obviously, what the local residents are saying about assessments not being made inside their homes. That does make it a little unfair. The report is a good one. In terms of,
I'm sorry, just on that report, I should have clarified my question a bit further as well. And do you think that the steps proposed will make a significant difference in line with what Mr. Sharanambidis has outlined?
I would think so, yes.
Okay, great. That's good to know. Sorry, and you can go into the next ones.
And the second point regarding complaints, just want to make you all aware, during the complaints that have come through to the council, we've had numerous officers deal with the complaints because there's been a change of board. Some officers have been on annual leave. So at different stages, there has been different with the complaints. And I've done my level best to through them. There may be occasions where complainants have put a complaint through and it may not have been picked straight away. Especially on that night, they may have called after 10 p.m, for example. From what I can see on the system, there has been a few attempts to call back before 10 p.m, but that hasn't always been the case. And since Mr. Rahili mentioned that he's received some voicemails after 10, I can confirm that is correct. There has been a few voicemails left after 10 p.m. And in terms of the third point, unfortunately, due to the arc that we had and the old system, I don't actually have much data. Any data prior to I'd say 2020.
Okay, thank you for that. I can see other hands going up, and I'm just aware of time and how much time we give this area. I'm going to come to the councillors, but everyone gets a closing remark, and I've just been working out timing, and I'm going to give everyone 2 minutes. So everyone who made a representation will get a 2-minute closing remark. So I'm going to go to the councillors first. Councillor, this is in your closing remark, just to make comments.
I had questions actually, which partly about when the noise report was undertaken. I wondered what Mr. Sharanambidis had to say about the fact that the noise report was done in April and May, when obviously the biggest bulk of the noise is June, July, August. I also wondered what the environmental protection view was on the comment that he'd made earlier, which is part of the noise report, I believe, which talks about people soaking up noise. So, you know, I suppose people may soak up noise if they're not creating additional noise. But, you know, that's the problem, that they can create as much additional noise as they're soaking up. So I just wondered where he felt the balance was there.
Okay, that's helpful. I'll go to Mr. Sharanambidis just on the point around when the report was made. And if you can be brief, I'd appreciate it. Thank you.
So, Mom, the report was made in order to have something for you because Mr. Chewett asked for it. So this is where we are in our reporting. We don't accept that the majority of complaints were made in the summer because there's only a small handful effectively. So there we are on that. They were sunny bank holiday weekends, so they were busy weekends. And in terms of the there are two factors, reverberance and soaking. You'll see that at paragraphs 3.27 of the report, which says where that balance lies. That's page 30. And in fact, whether there's 50 people or 150 people, the soaking effect applies, and that's discussed there, as well as the effect of reverberation, which is at 3.2. So those are dealt with there, and the way in which they balance each other out. And as you've heard from your own environmental health officer, so that's two experts now saying, yes, it's a good report, and they agree with the steps and the conclusions made by Peter Rogers. So that's doubly endorsed, which I'm very grateful to the environmental health officer for.
Great, thank you. And then, yeah, Mr. Patty, coming back to you on the question around people soaking up noise if they're not making noise, or if they are making noise. Just on that point, please.
Oh, I mean, I don't. Again, this would all have to be witnessed. I mean, we would have to carry out an assessment subjectively and possibly objectively. It's you could have 10 people or even 3 people in that so-called, barrel area, but if they're intoxicated and they've had X amount to drink, they could still cause some kind of disturbance. Yes, for example, even the trees will take in some kind of to some extent, but it's hard to make that assessment.
Okay, have we got Mr. Rogers here?
We do, and in fact, Mom, I was just going to say, I mean, his independence has been much maligned, so he is waiting in the wings.
Yeah, if we could just ask Mr. Rogers, thank you. If we could just ask you specifically on this point around people being a buffer to sound, but your view on if they're a buffer if they're making noise. Obviously, people could be a buffer if they're just standing there for the pure, the reason of being a buffer if they're not going to make any noise. Yeah.
Yes. Good evening. The situation is that people's bodies absorb sound. It's the reason why in concert halls the concert halls are treated so that the rehearsals are the same as when they are in a performance. So it's a matter of physics. What I've done is do some calculations based on the number of people, the vocal effort, and looked at that in terms of a predicted value. And then I compared that with the measurements that I actually took over the period, which is just after the complaint was made on the 13th of May, of which I wasn't aware of. So it does show that it's a representative period in warmer weather over the bank holidays. So the numbers, the actual measured numbers, match the predictions. So I'm very confident that that is what's happening. The other is one more thing, which is called the Lombard effect. And that is, you'll know when you're amongst other people, you make an unconscious vocal effort to raise your voice to be heard. And you'll know that if you're in a busy bar, etc. The more absorption there is around the people, the less that happens. So it's actually quite important that those on undercroft areas are doing their job, which is absorbing. Currently, they're very reflective. The only thing that stops that is when it's full of people.
Yeah, can I interject? I noticed that Mr. Charalambidis jumped in with a position and is pertinent to this point. So to be afforded the same privilege as him to jump in would be.
I don't think I did let him jump in.
Well, he did. Sorry, it's pertinent to this point, Chair.
I'm just gonna go back to Mr. Rogers with a question.
Can
Mr.
Rogers, may I then come in, Chair?
Just let me do this and then I'll go to the next point. So the thing that I'm struggling still to clarify is, are you saying from the nature of the space that if the people weren't there, it would be louder, even though those people are making noise? Is that what you're saying?
So almost. So when it's empty and it has no people in it, there'll be no noise from it. As soon as you start to have people, more than one person generally, because you're talking to somebody else, then you'll start to get people noise in the area. So it jumps from nothing to something. Now that noise that's generated is the direct sound that comes from the mouth, but it's also the reflected sound from the area around. And initially that reflected sound is a lot. So it adds up to the direct sound to make more sound. The issue we have here is as you fill it with people and you've got two competing things, one is the sound that's reflecting and being absorbed by the bodies. The other one is the vocal effort that people are making when they're talking to each other. So the predictions have been done on that basis. The measurements match the predictions. The conclusion from it is that if you were to consider a new house, a new property in exactly the locations of the residents, you wouldn't need to add any mitigation on the basis of the noise levels.
Sorry, can you just repeat that last point?
So if you use the British standards that are the basis for new premises, if
Right,
you consider,
okay.
Yeah.
Sorry, I follow your point now. Okay, I can see I've got other hands up. Mr. Ridley, I know you're really desperate to come in. Is it a point of clarity? I'm only taking points of kind of clarity from people.
Well, it's a point of clarity in the sense that when the pub were previously asked in the last hearing about how many people they would limit the garden to, they refused they refused to put a limit on it. You'll note from the committee report that they said, well, they wanted up to 120 people within the garden.
Yes,
and there's been no point. And this point that says people are automatically a net absorber of sound.
Yes. I'm going to
irrespective of
come
how
back. I'm going to come back to that point because I do want
demonstrably nonsense. Like
yeah, I
if
want to
I'm in
put
a
your
pub garden
condition.
shouting,
Yeah,
I'm not
okay.
a net absorber.
Thank you. Yeah, I think we've heard different views and the complications of this acoustic report. Councillor Lufkin, I'll let you come in, and then I want to just put the resident conditions to Mr. Chamberlain, and then we'll have to conclude this part, and then people will get their 2 minutes summing up. So if you've got anything else to say as a representative, you can say it in your 2 minutes. Councillor Lufkin.
Mr. Rogers, just some questions really. Are you saying that there is no noise in these people's flats? Is that because that seems to be directly contradicting what they say? I mean, we're hearing stories about not being able to put children to bed and things like that. Is it your view that that's not the case?
No, that's not my view. And I have my view as a fellow of the Institute of Acoustics, completely independent of the premises. And I also have a statutory declaration signed because my duty is to you as the subcommittee. So my advice to you is that is not the view. I've not been in there myself, but I do report on the evidence that was taken by Do Acoustics, who were able to witness inside. But I am able to do calculations to work out what the noise levels would be inside with windows open. So I've done that in my report, and I conclude that yes, there might be sound audible. That does not mean that a statutory nuisance, or indeed a nuisance or a public nuisance, exists. That has to be a substantial and a significant material interference of the way you use that premises, not just being able to hear it.
That's useful clarity. I'm going to come to, I'm aware that I've run really over time with this section. Sorry, Mr. Davenport, I know you've got your hand up, but I might come to you for your 2 minute summary. Mr. Charalambidis, if you could I just really want to, just to make sure that we've covered everything in the discussion before we're able to make our decision as a panel. When Mr. Hilly was making his representation, he mentioned three additional conditions that he would like the applicant to consider, and I just wanted your view on those. One was limiting the numbers to 10, no vertical drinking, and then closing the doors from the inside to outside, which I thought was happening. But if you would like to give the applicant's view on those three proposals.
In terms of the doors and windows, ma'am, you'll see that's point 18 of the noise management plan, which is at page 53. As for the limit on numbers, I can be brief and say no. Mr. Rahilly is not an expert. In fact, indeed, Councillor Lufkin puts it correctly when he says he's hearing stories. You've got a real expert that has given you his views on that. And in terms of no vertical drinking, again, I'm not going to accept that, though you've also heard from Ms. Davenport that the use of the tables has made a direct impact. So I think it's quite inappropriate to be held hostage by the well-meaning passions of a neighbour I'm going to be guided by the objective assessment of the independent expert that Mr. Chewett has asked us to appoint, which your environmental health officer, Mr. Patty, has agreed with, and commend to you the matters set out in paragraph 7 of the report, and not the whims of, as I say, a passionate,
It's
albeit
not-
well-meaning
yeah.
resident.
It's passion and whims, but it's also people's lives and experiences, isn't it? And I think Councillor Lufkin was trying to pick up on that point. That is, you know, I think we've heard some great stuff from the acoustic report in terms of the conditions, the 2 steps that have been recommended, and the environmental protection saying that they'll make a difference, which hopefully residents feel positive about. But I think, you know, it's still coming down to this. How can we just make sure that we're making the best decisions that's right for the use of the premises, but also those lived experiences for people?
Well, Mum, the point about lived experiences, and the reason I use my wording very carefully is, of course, as Amanda North will let you know, this directly relates to the Thwaites case. And the Thwaites case says you, as a committee, shouldn't let passions and whimsy override
Yes,
technical expert evidence, which is why if
evidence
there is a
isn't in the
ranking,
house, is it? That's where I think we're coming to. It's
doesn't matter, because Peter Rogers has said to you, you have measurements from inside the house. They were done by Do. You'll have seen in the statement prepared at paragraphs 38 and 39, page 61 of the supplemental agenda, that the local residents haven't wanted to engage with that. And of course, there are standards and assessments that are made on the technical data, which means Mr. Rogers can conclusively reach a determination as to what can and can't be heard in those houses and what the impact will be. So that's why the case of Thwaites tells you, when your experts give you some guidance, you must follow them, and you must not set it aside on the basis of passions and fears, no matter how well-meaning they are. There's a clear legal test that you must apply.
Yeah, absolutely. I don't think anyone's setting it aside. I just think we're trying to work out where evidence has been taken and what conclusions we can make. So, Councillor Rout, I'm going to come to you quickly, and I do actually need to move us on to our closing remarks.
Thank you. It was just a comment about a question really about the vertical drinking. I wondered whether or not the pub has considered the no vertical drinking at all, and what the licensee's attitude would be to that as a condition.
Well, we have considered it, which is why, as part of this ongoing conversation, we've put tables and chairs in those outside areas. They have the advantage, you know, if a tree, as Mr. Patty says, soaks up sound, so do wooden tables and chairs and people seating. The fact that people are drinking and having food means that it creates a different climate. So we have thought about that very, very seriously. The point is, however, that this is a pub run by the publican in accordance with the licensing objectives, not the whims of local residents. And you know, it's not for them to dictate how a premises needs to operate, and to impose a condition when you have no evidence on what the difference between vertical drinking may or may not be, as opposed to seated drinking would just be, in my submission, quite wrong. The reality is, as I say, it's predominantly seated. Vertical drinking has significantly reduced in the area, and that is more than sufficient. And this is not something that the experts, Mr. Chewett or Mr. Patty, are asking for. So for a layperson to make this request, I can understand where it's coming from, but it's not helpful.
And what about any condition around regular liaison with local residents?
Mom, it's already been offered, and in fact it's well worth looking at paragraphs 38 and 39 on page 61, because we have emailed the ward councillor and local residents, and they do not respond to us. And I see them all shaking their heads here, but if they're not responding, then there's not much we can do. We are really happy to have an email and a phone number to local residents, and you know what I'm going to suggest, perhaps Mr. Chewett or Mr. Patty, because they don't visit the premises enough, perhaps every 4 months. They're very welcome to come to our venue. They're welcome to invite the residents along, and we'll happily send them an email and ask them to come along if needed, so that we can have a local meeting.
And that would be an acceptable condition for you, would it?
We already engage, and I'm just waiting to get confirmation from my on my WhatsApp group from my client.
Okay. Councillor Lufkin, please, can you let me move to closing remarks? Have you got a final question?
Yeah, I guess I've got a question. That raises a couple. Mr. Chairman, Beattie's raised a couple of questions there that I'd like to ask the residents. Have you tried to engage with the? Mr. Chairman, Beattie says you haven't. Have you tried to engage with the premises? That's my first question. To the residents.
Yeah, if we go to Mr.
And the second question is, I'll keep it very brief, is Mr. Chewett, we raised the question of no vertical drinking. I'd just like Mr. Chewett's view whether that would help things.
Okay, brilliant. Sorry, Ms. Davenport, would you like to come in and talk to that point around engagement? Oh, sorry, you're on mute.
We also have Sharon Patrick here, who's a councillor who's been involved in the conversations that we've had between us and the pub, as it felt that it was appropriate to have some form of mediation, because this has been such a stressful experience for all of us over the last 3 years. And we have definitely said that we would be interested in meeting with the pub, and we've been forthcoming and we've been open. But there have also been times where that hasn't been reciprocated by the pub. There's a lot of mistrust between us, and I don't think, I think that's founded on, evidence of there not having been transparency, basically, with what has been going on. I don't know if Tommy, you want
to... and just to push on that one a bit, so this offer of a meeting for every 4 months with including Mr. Chewett and Mr. Patty as kind of the responsible authorities, as a kind of helping with that kind of that communication and that discussion. Does that sound positive to you?
Chair, may I come in? I think I had my...
I'm just going to go back.
Sorry, I thought it was...
Yeah. I think if it was clear what we were doing in that meeting, in terms of, okay, are we meeting to discuss how things are going?
Yeah.
Have it improved? Do we feel like this is better for us? What are the sound levels? Then that could be something positive. Yes.
I think that is the proposal. I'm just going to get a nod or a shake of the head from Mr. Sharon Beattie's. That's my understanding of the nature of what that meeting.
Absolutely. We can say every 4 months we'll invite the local ward councillor. We already email her. We'll invite Mr. Chewett and Mr. Patty. We're happy to listen to the ongoing concerns, although we must also be very clear that the concerns of the individuals are not necessarily the concerns of the community, and that's why it's really important that Mr. Chewett is there and Mr. Patty is there in order to make sure that we're getting the right balance.
Okay, and Mr. Rahili, I knew you wanted to come in.
In a sense, I think Mr. Sharon Beattie has just made the point that, of course, we can kind of make these meetings. It's about what teeth or what consequence it has as a result. I think the pub last tried to make contact 1.5 years, 2 years ago. It was certainly prior to the last hearing last June. And since then, they've just demonstrated that actually, and I think residents have disengaged because nothing happens as a result of that contact. We have historically in the past over a number of years had those conversations. Nothing really changes, nothing meaningful. So yes, it's the easy condition, isn't it, for the pub to say, oh, we'll meet with you every 4 months. But quite frankly, without the more substantive conditions, so what? Because as Mr. Chambliss has just implied, basically we'll listen, but we're not necessarily committing to take any action as a result of that. So yes, of course, we want that condition. I think the pub has to think, which is not historically, and that's why residents actually, if we're honest, have stopped engaging, because we did that historically, nothing happened.
Okay. And I'm just going to go to Mr. Chewett on the question from Councillor Lufkin on vertical drinking. A view on vertical drinking.
It's not something that we've sought to impose. I think that the area is mostly seating anyway, so I'm not really sure if that would make much of a difference.
Thank you, that's helpful. I'm going to move to closing remarks. Mr. Davenport, if you want to include your comment in that 2 minutes, I'm going to move us to that. So each person who's spoken, I'm going to give you 2 minutes. So I'm going to go with Mr. Chewett, Mr. Patty, and then Miss Davenport, Mr. Rahili, Miss Harvey, and then Mr. Sharon for your 2 minutes. I'm going to try and I need a timer. Have I got the phone? Great. So, Mr. Stewart, if you want to start your representation.
Thank you, Chair. I sought this review application with the aim of trying to resolve this matter, which has been ongoing for some time. Whether that's actually been achieved or not, we'll obviously wait for the decision that you make. It sounds to me as if the residents that you've heard from are still concerned, still not happy that the measures that have been undertaken so far and those that are proposed have made any difference. But no doubt you'll hear from them. So I do, as I mentioned before, I welcome the acoustic report. There are still some, in paragraph 7, some works that could be further undertaken, which may hopefully go some further way to reduce the nuisance that's being caused. But it does sound to me like there may still be some nuisance issues. But if we do have these conditions and ongoing dialogue between the opposing parties, hopefully that will go some way to resolving the issues. Thank you, Chair.
Thank you. That was incredibly helpful summary. Mr. Patty, I'm coming to you next. Thank you.
It's going to be hard to top that. I think again, what Mr. Stewart has said is spot on. It's, I suppose, the only other remarks I'd like to make is hopefully in the future, hopefully the noise disturbances don't continue at all, and if the remedial works that are carried out completely get rid of the disturbance to the residents, fantastic. If they don't, please do report them to us, and we'll make an active effort to visit before 10 p.m. so we can make an assessment in relation to this, and obviously take any necessary action. But just as we said a few minutes ago, look forward to the if it is a condition that is imposed, meeting up every 4 months. That sounds like a fantastic idea. I think that's all from environmental protection. Thank you.
It's really helpful. Who am I going to now? I think it's Miss Davenport now. Sorry, I'm looking at a couple of documents. Yeah, Miss Davenport, if you want to give a 2-minute final closing comment.
Yeah, I think it's just mainly to say that there is, the suggestion that basically our concerns, our passions and whims is very far from the truth, given that we as residents have basically committed to, addressing the issues with the pub in a very measured way, relying on the council, talking to the council over the last 3 years. This is, and it's a nightmare. It's like it's completely changed our lives over the last 3 years. I really beg this committee to accept the conditions that Stewart has recommended for the no customer access, because I don't feel that the 4-month meeting is going to address, basically the public nuisance that this pub creates and continues to create and makes our lives really difficult. And it's exhausting doing this job of raising complaints through reporting noise processes that not only change over time, but also, you don't have the energy to do because you thought it was going to be resolved when this license was being reviewed last year. We all work full time. We've all got lives. We don't really need this extra stress in our life. It could be very easily resolved by basically having these conditions upheld and sticking to the plan of what the pub license covers.
Thank you for that. I really do appreciate that summary and for the experiences and for you all coming here to share those and the time you've had to put in to make those representations. Mr. Rahili, I'm going to come to you for 2 minutes.
Thank you, Chair. And just to really echo that, there's, I think, really unhelpful language about passion and whim. people don't do this for fun. Myself, Emma, Marcy, other residents aren't, you know, much as I love local democracy, aren't doing this because it's, you know, on a whim, on activity. We're doing this because it has such a detrimental impact on our lives and our experiences of living in Hackney, and that's why we are here. The amount of effort, you know, lots of discussion about the number of complaints. I'd also say people don't know where to put complaints. David, I'm sure if he was allowed to speak again, can attest that lots of people have directed the licensing team directly, not necessarily the environmental health team. People have contacted their council, not councillor, not necessarily the environmental. So those complaints go to a whole range of different places, and that level of noise is there. We are here because the pub failed in its previous licensing application. It recognised there was an ambiguity in its licence. It brought forward an application last June to try and regulise the use of this space, which was rejected. And that's why, but yet they've continued to use that space. They've continued to go against at least the spirit of that hearing and not demonstrated any willingness to change. And that's why I understand the council have had to bring these things forward. As I said earlier, in that hearing, they absolutely refused to put any limit on the numbers of people who were in there. They talked about there being over 100, I think 120 people. And yet again, they have refused to put any limit or any suggestion that they will work with residents to limit the impact on that. We've relied so heavily, or rather the applicants, or sorry, not the applicants, the pub, have relied so heavily on a noise report. And I really stress a noise report that was carried out in April and May, and that is just not the period as residents when we see this problem. It is a problem in the warm summer months. So great, we've got a spurious piece of evidence that was taken with some readings that were taking place when noise is not being carried out. So I'm not doubting its technical ability, but it is not a relevant thing because it's not carried out when the noise is the problem. And I just, yeah, we're trying in this case to implement the spirit of what has already been agreed by the council, that these shouldn't be covered areas. The pub has demonstrated time and time again that it will try and get around that. So I do really urge the committee to also impose the limit. As I said, 10 is the number of people that would be seated in that area that is allowable under the plans put forward by the council. So that, and just, sorry, one final point, Mr. Charalambidis said that they are already closing the doors. I mean, if there's a means possible, I can demonstrate a photo taken yesterday. Okay, they're popping them open and they're demonstrating they're not meeting the conditions of their existing license.
Okay, well, that's in a way something that, if it's enforced, may make a difference to the noise, but we can make sure, make sure that that's happening. Mr. Charalambidis, I'm coming to you now for your final closing remarks.
Well, thank you very much. I'm really grateful to...
Sorry, Chair. How about Miss Harvey?
Oh, sorry, Miss Harvey. Sorry, apologies. Yeah, if you can, got 2 minutes. Sorry, apologies. Thanks, Councillor. Sorry, Miss Harvey.
Yeah, well, it's been a long 7 years. I first made my complaint with Gouch, Patty. There's record of it. I would like to know, have you seen the videos of what was going on as the panel seen? Right. So, yes, the noise has been reduced slightly. I am horrified. It's like science fiction. It's like reading science fiction, because I know when I'm in my garden and there's a football match going on and the ground is shaking outside, yeah, I'm not being over passionate, right? Or being extra. We know what we're going through in our homes, which we've paid for. And I don't think it's right, yeah, that the pub, just to make as much money as they can, should have this effect on people in their private homes. Yeah? It's been 7 years. There's mental health going on in my house. There's people that have had to leave where I live. Yeah? So you don't make it look like it's nothing.
Thank you, Mrs. Harvey. I really appreciate the experience that you've had and sharing that with us. I'm sorry for the way that that's affected you and people in your home. I'm going to go, I'm now going to go to Mr. Charalambidis for your closing remarks.
Well, I'm really grateful to Mr. Chewett and to Mr. Patty, who effectively have agreed with Mr. Rogers. They endorse his report. They accept the findings of the report, and what I understand that they're saying is implement the measures of the report. I think they directly referred to the matters, in paragraph 7, saying that they may help and want to observe them. And what those 2 measures are to treat the undercroft areas, the 2 covered areas, with acoustic absorption, and then improve the high-level screenings. We will undertake to do that. The EHO as well says, like, do the remedial work and see what happens, particularly over the summer months. So what we're suggesting to you is that you do ask us to do those remedial works. What I'm going to further suggest is that then we invite Mr. Rogers to undertake a further report at the expense of obviously the premises. We really welcome Mr. Patty's and Mr. Chewitt's engagement. We will write to a representative sample of local residents and see if they're willing to put sound recording equipment in their gardens or in their homes. I suspect Mr. Raheli says he can hear it in his front garden, in his front room. So that sounds like it might be the most noise sensitive. If the works are done imminently, it will mean that we can pick a date in July or August when it's really sunny and the outside areas are being used as we say they are. We're then able to prepare a report. In 4 months' time, I make it mid-September. That report could be presented to the council and local residents, and we can observe what measures have been made. In the meantime, of course, we can also assess whether these are personal and peculiar matters to the complainant, or they have wider impacts or not, because I note there is one supporter, but we have many other supporters that value this community pub, the outdoor space. Outdoor space is never more important than now. COVID taught us that, and indeed the government policy is to encourage greater use of outdoor space. So, Mum, I'm going to commend that approach to you. It's the appropriate response. It's also the legal response and a lawful response, because it is based on real evidence by an independent expert, which has now been endorsed by your 2 responsible authorities. And that's the lead that you should follow.
Yeah.
Thank you.
Thank you, Mr. Sharolambides. That's actually where I was getting to with my conclusions, that I think it's incredible. I'm going to ask the subcommittee for any final comments in a minute, but just to comment back on that, I think, we've heard that some conditions have already been implemented. I need to make sure that absolutely all of those things are happening, like the indoor-outdoor door. We've had the agreement that those steps within the acoustic report are going to take place, that the 2 that you've described. And that's exactly what I was hearing. I feel like there's been a bit of a disconnect between the evidence that we've been referring to. Obviously, we've heard some real, personal disturbance that's experienced by some of the neighbours and the impact that's having. And I really do welcome if we can organise that acoustic report to take place. I think maybe Miss Harvey's garden, within Mr. Raheli's home, and if we organise that to take place over the summer to then have that review, I feel like that would be really positive. Okay, I'm going to bring any final points of clarity from the subcommittee members and then bring us to a close. No, got a shaking of the head from Councillor Lufkin. Anything from Councillor Raup? Just come in.
Sorry, I'm a little confused about which of Mr. Chewitt's recommendations Mr. Charalambidis has accepted. So, for example, the stuff about the television outside and what have you, is that all taken on board?
Mum, that's already been done. It's been over 11 months since we've had a TV or any sports in the thing.
Okay, no, I'm just
the outside area.
I don't want to get into that in the conversation we have later on. I don't want to muddy the waters by not having understood that properly. Thank you.
The only bit we disagree on, and now we do agree on, is we disagreed on the outside areas, the 2 covered areas, as they're called, being closed off. We now seem to be agreeing that keep them open, do these measures, and then review by the end of by mid to late September.
No, that's very.
No,
Yeah, is that what Mr. Chewitt is also agreeing with or not?
So that's what he said when he said, sure, put in the paragraph 7 may help.
Maybe
That's what
Chewitt
your
could contribute
environment.
to
Yeah, I'll
that.
just let Mr. Chewitt come back in.
I think what I said was obviously I'd made this application with the hope that we could resolve this ongoing and sort of long-standing matter. Whether that's been done or not, I'm not entirely sure that it has. What I did say was that in the acoustic report, there are some additional measures that have been proposed. I think it'd be useful for those to be implemented at the site. But I didn't Leo go specifically to say that those areas that I put in the initial application to be used.
I think what the panel, what I'm hearing and what the committee needs to take away is what has been agreed and what has been spoken to this evening, which is the conditions have been accepted, the written conditions, and lots of those are already happening, but we just need to make sure that they are already happening. We've got people who've agreed with the content of the acoustic report and with the 2 steps that need to be taken to further soundproof the area. I think the committee need to discuss whether we feel that that's enough to abate everything that we've heard this evening. And then we've just had the commitment from Mr. Lambides about the need to do that further evidence of the noise that people's experiencing to see if those steps has made any difference. But it's for the committee to consider the proposal that was made in the licensing report. I'm going to go to Amanda first.
Yes, thank you, Chair. I think we also agreed on a condition for local residents to meet with environmental
Yes,
licensing.
having that first meeting in September was what I heard. We do the further acoustic report.
Yes, yeah, and
of
also
the evidence from people's homes.
Yes,
and then have that meeting in September, which includes the local councillor, Mr. Chewett, Mr. Putty, residents.
Yeah.
To review that report.
Chair, I think it's very important for you to ask Mr. Chewett, is he still maintaining his application that he wants these 2 covered areas to be closed and these remedial works carried out, or is he agreeing to keep them open and then the remedial works carried out? I think that's what you need to be clear on.
Thank you, Amanda. Mr. Chewett, do you want to speak to that point?
That was my original application. What I would say is that we've heard a lot of evidence this evening and spent a lot of time just talking about the acoustic report. The suggestion from the residents that are on the call is that these works done so far haven't made any difference, and that the further works it's not clear whether they will or not. So I'm going to what I will say is that I made that original application. Since I made that application, a lot has changed and a lot of evidence has come forward. So I'm asking the licensing committee really to make that decision as to whether whether those areas should be excluded or not.
Okay. And I think that is the decision that we need to make. I know that. Okay, Mr. Sharon.
Mr. Chewett's not an environmental health expert, but you have an environmental health expert. He says, make the remedial works. It may get rid of the disturbance. Now, you can't just put down, this isn't about pleasing the residents.
Okay, I'm not going to open up the debate again. I think we've heard.
It's important because people are making legal errors. You're controlling how long we can speak for, and there are serious financial consequences, and there are serious community consequences.
I think we've given people a really fair hearing. I feel like I've gave.
So you say.
Sorry, if we can speak.
Why don't you ask the environmental health expert that question?
Okay, I think we've done a lot of that. I think we've. Mr. Rahili, if you want to make a final comment.
The barrister on behalf keeps interjecting and making what apparently legal points and then talks about the financial considerations of the pub. They're not a material condition or consideration of this committee. So don't try and call us the big language.
I think the point that he was trying to make was around having a fair hearing rather than the financial considerations of the pub within the context of the license. It's more to do with offering a fair hearing, which I hope that people feel that they've had the opportunities to say the things they've wanted to say. I feel like we've had, tried to summarize and get to a good point with those concluding remarks. Councillor Lufkin, you just put your hand up and down. I didn't know if you wanted to say anything. Okay, so I feel that Councillor Rao.
Sorry, I did just want to question Mr. Tuitt a little bit more on what he was seeking to clarify with by bringing this today, because it does seem to me that there's almost two issues here. There's the noise issue, and then there's the area issue as well. And I suppose the issue that I'm concerned about is if we as a panel go away and decide, yes, we will accept the conditions with the sound, etc., which Mrs. Cheryl Ambers has talked about, and we're not going to close down the areas at the moment, the covered areas that Mr. Tuitt was looking to seek to close. Does that mean by default that we are therefore endorsing that use as the licensed area? So in other words, if we do that, are we essentially giving the pub the opportunity to carry on indefinitely using those areas? That's something I would just like some guidance, perhaps from Mr. Tuitt, perhaps also from Amanda Northorne.
Mr. Tuitt, if you'd like to come back on that point.
I don't think there needs to be a concern about endorsing whatever this, for example, if you were to decide not to restrict the use of those areas, there needs to be a concern about that. This application is partly because of the refused new license application and the conclusion made by that panel about those areas. And I felt that it was something that needed to be looked at again by another panel in this review application. So the licensee I don't think you need to be concerned about what might happen in the future. We'd still have options available to us. If for example you decide not to restrict the use of those areas and the licensee comes to us to make a further application of some sort, that's still a possibility. So I don't think you need to be concerned about any future endorsement or anything like that.
And I understood from the conversation we had earlier that it's to do with the use of the premises, and the way the premises can be used. So I don't think it's in line with endorsing that in the way. Okay, I feel like I'm going to bring us to. Did someone say something? No. Okay, I feel like I'm going to bring us to a close. Amanda, just to confirm, the decision will be made in 5 working days and published, but we're able to give that. Can you just confirm when the
skeleton decision will be issued tomorrow, if it's made tonight, or as soon as possible after it's made, and then the written decision should be issued within 5 working days.
And Chair, point process, will that skeleton decision be automatically emailed to us tomorrow, or is there someone we can contact? Just, it would be useful to know what
it's the licensing officer who you've been in contact with so far. They would be the point of contact. Thank you.
So just to clarify, the skeleton decision is sent to who, Amanda? Is it just the applicant, or is it sent to everyone who's been involved?
It's not all. I think you have to request it if you want it. That's
okay.
My understanding, that it's requested. But
okay, Mr. Tuitt.
Just to manage expectations with this one, because of the nature of this application and the discussion, this decision might take the full 5 working days to be published or to be released. So we will, from licensing point of view, get in touch with people as soon as we have that decision. But I just I'm just a bit unsure if it will be tomorrow. So that's something I thought it might be worth saying.
Okay, thank you for that clarity. And you do have, contact with the licensing officer. Okay, we've concluded the majority of the agenda. I just have to state that there was agenda item 7 that we don't have any temporary event licenses notices to consider, and that I am bringing the meeting to a close. So if Mario, if you can and the recording, and then, yeah. So thank you, everybody.
Thank you.